Good afternoon, everybody. It's great to be back with you here on the 16th of May. It is looking beautiful out there, about 80 degrees here in Midtown Manhattan, and spring is definitely upon us. And there, of course, have been some major changes, including the end of the public health emergency on May 11th at the federal level. And we're going to bring you up to speed on that, as well as on other topics that we think are important for you to hear about today. So Kathy, if you'd go to the next slide, I will walk the group through what we intend to cover today. I will address where we stand with the New York State budget. Of course, we have a deal and we have a budget, but we'll unpack some of the elements in a little bit more detail than we've done previously here on the program, just to make sure everyone has a sense of what it is that's happening out there. And then I'll get into the public health emergency just a little bit more than I have again in previous programming. Roger Bearden, who's new to Bond, who's an attorney that joins us from many years working in New York State government at leadership levels. You'll learn more about Roger in a moment. We'll dive a little bit more deeply into some of the PHE and end of pandemic, as it were, relating implications. Barbara Lee is back with us, an attorney, as you know, who has a deep and very established practice in higher education. She will be discussing remote work and the reasonable accommodation posture in our changed environment, where hybrid is real and here to stay, although not in every workplace. And so Barbara will have some pointers concerning that dynamic. Seth Gilbertson, also another higher education attorney who's been a regular on the program, will be here to talk about artificial intelligence in higher education. It's a topic, AI that is, that we've covered in a number of different presentations that precede Seth's, but we wanted to do a deep dive on education just because we thought it was important to so many of you. We'll move then next to Allison Roach, who's an associate that also just recently joined Bond in our Buffalo office. Allison comes with preceding experience in labor and employment, and we're glad to have her with Bond and on the team. And she'll be talking about a National Labor Relations Board decision that we think you'll all want to know more about. And then I'll wrap things up. So Kathy, if you could go to the next slide, I'll walk everyone through what I intend to cover today, again, starting with the New York State budget. So what we addressed in the previous presentation when I was with you a couple of weeks ago was that the budget was essentially hot off the presses and we were starting to get a better understanding. Now that we've had a little bit more time, again, I'd like to highlight just some of the key matter that all of you should really be able to walk away with from today's presentations. And so in terms of rate increases, looking at the Medicaid program, we know that hospitals got a bump up of about 7.5%. Outpatient providers and assisted living 6.5%, and nursing homes are presently at 6.5%, although depending on federal approval, it could go to 7.5%. We'll see. But what we've also heard from a number of different corners is that these increases are not keeping pace with the realities of what it is to deliver care from the healthcare provider perspective. There are also labor contract agreements that play into this, the costs of which are not, in many respects, easily covered by way of these increases. And so there's a lot of concern that healthcare providers around the state are continuing to voice, and we're tracking this dynamic quite closely on your collective behalf. And as you know, we're happy to serve many of you with your legal needs in this space. Other things that we want to just touch on are, of course, the 340B program, which is a discount program for prescriptions that makes a large difference in a number of settings in terms of essentially cost controls. But New York State, through the budget, has changed in many respects the boundaries of the 340B program as it, again, relates to some of those discounts. And that is taking some time for the dust to settle. And there is some certainly concern about that change as well. It's one that New York State undertook for purposes of cost controls. As best we understand it, there are also, though, concerns that this is not necessarily a stabilizing move. Let's talk about funding for healthcare transformation. That's a place where, as I've talked about before, I spend time in my practice. And here we saw more funding written into the budget for healthcare transformation around capital projects, the statewide healthcare transformation program in specific, vital access provider programming, which is more on the operations and program side of the house. That too has more money written into it. And another program that came out of the budget last year, the Vital Access Provider Assurance Program, which was really oriented at the time for nursing homes that were dealing with the unique and pressing challenges of the pandemic on their operations. That program remains, and it has been expanded in terms of its eligibility to include a limited set of hospitals and certain performing provider systems, essentially legacies of the first round New York State had with the Delivery System Reform Incentive Program. And as those entities shift into whatever comes next with the 1115 Medicaid waiver amendment, which we've also talked about here, there is some money that is available or will be ultimately put forth in terms of helping that transitional process along to whatever is coming when the waiver is ultimately approved. We're not going to talk more about the waiver now because we'll have a fuller chance to discuss that on future programs, but know that we still don't have an agreement yet on that, but New York State and CMS continue to negotiate. One more reminder, in terms of minimum wage increases, we're at $17 in New York City, and what we're going to be seeing across New York State by 2027 is a full statewide $17. So essentially, to start, it's New York City in 2026 and the surrounding geographies, and then we go out beyond that. Next slide, please. So other things that I just want to quickly highlight, knowing that there are other presenters that are going to follow me, and I want to make sure that everyone has an opportunity to connect with all of you. Know that community health worker services are now Medicaid reimbursable based on this budget, provided CMS signs off, which will have a major role in terms of some of the work around social determinants of health in New York State. So that's one we're watching closely. We mentioned a bit in previous broadcasts about healthcare transactions, and there's going to be a set of increasing reporting requirements that were also approved by way of this recent budget action. And there's a lot yet to be written here, no pun intended, in terms of the regulations and ultimately what it is that will need to be reported to New York State. While New York State won't have the control to essentially stop these transactions in a formal sense, the reporting requirements may serve as a secondary means of New York State's greater involvement. More certainly on that in future broadcasts. Lots of money in the budget for behavioral health that we've mentioned before, as well. A call by the governor to control agency staffing and to bring certain governors, again, pun intended, with regard to the costs there. We'll be tracking that closely. And then one of the things that we had raised in previous discussion was that there were proposals to move a variety of oversight functions out of the State Department of Ed and into the Department of Health with regard to medical professions. None of that survived into the final budget. So we'll be watching that next year and thereon. Next slide, please. So between now and June, which is when the New York State legislative session typically ends, we know that there may be some focus on justice-involved populations still. There are some hard feelings, I think it's fairly described as, between the governor and the legislature around some of the changes around bail reform that were in the final budget. And so we may see some standalone legislation that goes forward essentially as counters to that. Supportive housing, we know that there was a large proposal that the governor put forth in her State of the State that did not make it into the final language of this budget and ultimately was stricken in order to get to a deal. We'll see what happens, whether there are any standalone pieces of legislation that move forward in these next weeks. Alcohol laws, in the context of the pandemic, everyone has seen that there are different ways of doing it than we presently function in New York State, and there were lots of relaxations, of course, brought by the pandemic. There's an interest in seeing some of those made permanent, and so more may come there. And Roger Bearden, as I mentioned, will be presenting shortly, and he'll be covering interstate licensure, scope of practice type elements, and so stay tuned for that. Next slide, please. And then just a couple quick elements for all of you with regard to the public health emergency, just shifting gears there. First, as we've noted, of course, it's news that you can't miss. As far as the federal government is concerned, the public health emergency concluded on May 11th, and this was long rumored. It actually happened, and the World Health Organization ended the analog at the international level on May 5th. So we're in a very changing environment for sure. Thank goodness, after all that we've endured over these last 3 years. There are going to be changes in terms of COVID test cost coverage that we'll be tracking, that we've signaled to you here before. Vaccination requirements are likely to ultimately change, but in New York State, they remain in place for healthcare providers. The federal government has signaled it will be changing there, but it hasn't happened quite yet. And telehealth is another space where there's going to be a lot of change. So more on that again in a moment from Roger, and we'll be coming back to that topic. So let's move to Roger now, if we may. It's a great time to introduce him. And Roger is an attorney with more than 2 decades of experience in the health and human services spaces. And he joined Bond after about a dozen years or more in New York State government as an executive deputy commissioner and general counsel for the New York State Office for People with Developmental Disabilities. He also was special counsel, in the governor's office, and was chair of the New York State Commission on Quality of Care and Advocacy for Persons with Disabilities. So Roger, before that, also practiced law in more traditional facets. And so he brings that wealth of experience to Bond and to all of you. And Roger, really glad to have you with us. Welcome to this program. Love to hear what you have to say about where we're heading as we move from the PHE to whatever is next. We're all going to be learning this together.
Gabe, and thanks so much for having me. I noticed in the Q&A there are several questions that were generated by Gabe's presentation that may overlap, and I understand the format is we'll have an opportunity to loop back near the end of the formal presentation to see whether we can capture some answers to that, and if not, to take those conversations offline. So, Gabe already mentioned that the federal public health emergency ended on May 11th. There's a parallel New York State executive order, which is currently slated to expire on May 22nd. That is the order that is currently permitting out-of-state professionals to practice in New York State where that would otherwise be prohibited. Get into that a little bit, but there's currently also a bill pending in the legislature that would extend those authorities. And so, that's something we're tracking closely. And so as we approach that May 22nd deadline as to whether the governor chooses to extend that, particularly in light of the nursing shortage that's continued to be felt in New York State, and or whether the legislature passes the legislation that's currently pending, and whether the governor chooses to sign that. So, mentioned previously, obviously throughout the pandemic, there were substantial innovations, particularly in the area of telehealth and telepractice more generally. And, some of those authorities will continue beyond the public health emergency. Some have sunset, and it's outside the kind of the scope of this forum to be able to go into the kind of all the nuance of that. But some things folks, would going to need to think about as they approach this new future. One is really who the payer is, depending upon who's paying for the service, Medicare, Medicaid, private insurance, to that limited degree to which there are private pay services, that those rules are often different, both as to what is permitted for telepractice, what is prohibited, and then what will be paid for. Whether the rate will be equivalent to the rate of providing an in-person service or some lesser rate. And so, some of the factors that come into that is, throughout COVID, there were changes in terms of what could be an originating site, where could the provider be sitting, where could the patient be sitting, whether either of those places needed to be a physical location that is subject itself to licensure. And there was legislation on a federal level last year to allow for some of the Medicare flexibilities to be continued more permanently. And then some were extended to December 31, 2024. So that's something that just needs to be carefully reviewed in terms of both from a compliance standpoint, because there may have been opportunities pursued through the COVID period to expand service, which are now no longer available. And there conversely may be opportunities to explore new business models that were previously not thought of. And once again, it's going to be a product for Medicare, really a federal policy, Medicaid, because Medicaid is a federal state partnership. You're really looking at the rules that are set by the state. And then, each within New York itself, depending upon the state agency or the type of service, you may have separate rules that apply that really need to be looked at carefully. So there may be different rules that pertain if it's a school-based health clinic versus a non-school-based health clinic, whether the services being rendered are traditional health services or mental health services or therapy services. And then, many other areas that I think are really very much in flux at this point. There were prescribing changes made throughout the pandemic, some of which are being preserved, some of which are not. Consent requirements, what does it take to manifest consent to a particular service or treatment? And mentioned previously the cross-state licensing of professionals. And, obviously we continue to have in New York a massive workforce shortage in the healthcare industry. And so how does that interact with state licensure requirements in particular is going to be an ongoing conversation. And then on a more compliance level, there are any number of innovations that were offered in terms of the ability to have alternate documentation when you're engaging in service provision. And some of those, once again, are going to be preserved, and some of them are going to be no longer current. So that's really, I think, for us, a sort of a treetops conversation in terms of some of the things to think about. And the point being is, if you're in, either the health or related spaces, now would be an excellent time to appraise where you are, both from a strategy standpoint, what opportunities are there to pursue new lines of business or to pursue business in a way that you hadn't thought of before. And then from a compliance standpoint, if now would be a very good time to think about your business practices, see what may have developed through COVID, and figure out whether or not those practices are ones that can or should continue throughout. So let me make an attempt to throw the mic back to Gabe. And I saw that, Gabe, you were answering some questions in the interim. I don't know whether there's anything that needs to be discussed now or later.
Well, thank you so much, Roger. Your perspective is really appreciated, and we look forward to having you back on the program as you continue to serve Bond and its clients and have more to share on these and other topics. At the moment, there isn't anything that I observed in the Q&A, but of course, please stay with us. And if there are questions that arise that you can respond to, looking forward to your help there. Let me now turn to our next speaker, if I may. So Kathy, if you could advance, there we are. Great. It will be Barbara Lee who's with us. And Barbara has been on this program a number of times previously. Barbara is someone who focuses as well on higher education, like Seth, as I mentioned, and she has a deep set of experiences around academic and student affairs, faculty tenure and promotion, diversity hiring initiatives, governance issues, and sexual harassment issues and policies. Before joining Bond, as you may be aware, Barbara was Senior Vice President for Academic Affairs at Rutgers University and remains on the faculty there. Barbara's here today to talk about workplace accommodations, reasonable accommodations specifically, as we all figure out what it is to work in a hybrid environment, or in some instances, ones that are reverting back to the way it used to be in 2019, where there were desks and it was more of the traditional format. So Barbara, I'd love to hear more about what you're seeing in the higher ed space, and I look forward to learning about the guidance that you have for our audience. Thank you in advance.
Okay, thank you, Gabe. And actually, what I'm going to be talking about today is relevant for any organization. Certainly colleges and universities are facing this, but so are non-educational organizations. So I've made my presentation somewhat more general so that hopefully everybody on the webinar can benefit from it. So we all know that many organizations functioned during the pandemic with all or most of their employees working remotely. It's just what we had to do. And surveys of employees show that many employees actually prefer remote work at least part of the time, and many of them would like to do it full time. On the other hand, many organizations and their managers believe that the work is done more effectively if the employee is present in the workplace, hopefully full time or at least in a hybrid fashion. And of course, there are a number of jobs that can't be performed remotely, or remote work simply is not as effective as face-to-face. So we have a wide range of issues here to deal with. Now, before the pandemic began, many courts and non-discrimination agencies said that regular attendance at the place of work was an essential function of the job. Then the pandemic arrived. Courts and equal employment agencies have modified this earlier principle, and this is no longer a defense to a discrimination claim. So we are not able to say showing up at work full-time, face-to-face is an essential function of every job we have. That's clearly not going to work anymore. So some of my clients have told their employees that all employees must come to work every day at the workplace. It is policy with a capital P. And I need to explain to them that it may be policy, but it may not be good law. So it's clearly their performance, their preference that people come to work full-time at the workplace. So let's discuss how such a policy interacts with the law. Next slide, please. So we all know, and I've got fundamentals here, I suspect that you already know all of this, but under federal law, employers with 15 or more employees, and under New York law, employers with 4 or more employees must provide a reasonable accommodation for employees who meet the definition of an individual with disability. So this is the definition. They have to be qualified in that they can perform the essential functions of the position. And I'm going to be talking about essential functions because that's really the heart of the matter, with or without reasonable accommodation. They don't pose a direct threat by requesting an accommodation that exposes the employee or the coworkers or others, students, clients, customers, to danger. And thirdly, the employee with a disability has to be qualified in that they do not pose an undue hardship to the employer, either financial undue hardship or a functional undue hardship. Next slide, please. So what is an essential function? Well, that's something that the employer itself must answer. The fundamental job duties of the employee are the essential functions of the job. They are duties that the job was created for, or they're duties that other employees either can't do or aren't available to do or don't have the skill or the education to do. They may require special expertise that other employees don't have. And these essential functions would need to constitute the majority of the employee's time at work when you add it together. So how do you provide evidence of an essential function? Well, hopefully it's in the job description. but I would bet there are 2 or 3 people at the webinar at least who are thinking, we haven't updated our job descriptions very recently. We really need to do that, particularly if we are getting requests for reasonable accommodations for remote work. So evidence is in the job description, I hope, you hope. If it's not today, hopefully it will be very soon. Also, the amount of time spent performing the function, the consequences of not performing the function. In other words, how central is it to the work of the organization, and the work experiences of past people who worked in that job. These all could be evidence of essential functions. Next slide, please. So you, I'm sure, are familiar with this term, the interactive process. And to be frank with you, in some ways, and this may sound a little bit strange, but it may even be more important that you go through the interactive process with the employee than what the ultimate outcome of the decision is. And the reason is that both the state and federal agencies that deal with disability discrimination law are not happy if the interactive process has not gone through. Even if it's obvious that there's no reasonable accommodation that is possible, the employer must initiate the interactive process and demonstrate that they at least thought about it. They talked to the employee, they looked at the medical documentation, and they tried to think of ways that the employee could do the job. Now, clearly, if it's a truck driver or a factory worker or delivery person or mechanic, they cannot perform the job remotely. But the good faith effort of the employer is very, very important if a claim is filed. Medical documentation is also very important. And we find that medical documentation often isn't very good. So you may need to ask the healthcare provider to be more clear, to provide more precise information about the employee's ability to perform the essential functions of the position and the limitations of that condition, which mean they can't perform the essential functions of the position if they, unless they are accommodated, of course. And also their ability to travel to your workplace. That's frequently, particularly during the pandemic, we saw a lot of complaints from employees that they needed to work at home because they could not use public transportation to get to work, or they had no other way to get to work. And so that's a consideration that needs to be thought about as you're going through the interactive process. Next slide, please. So the medical documentation should include a description of the functional limitations. And don't forget that they're not just physical, they may be psychological. And we'll talk about mental health issues in just a moment. They need to include the proposed reasonable accommodations that the healthcare provider believes would enable the individual to perform the essential functions of their job, how long the functional limitation is expected to ask, and if the employee wants full-time remote work, why can't the employee travel to work from the healthcare provider's point of view? In other words, it would be a health issue, a disability-related issue, not just because it's inconvenient or I live 2 states away now and can't get to work. Next slide, please. Okay, so what kind of accommodations then need to be considered? Technology or software are very, very common accommodations that are given to employees with disabilities who need to work remotely. They can be reassigned to a vacant position, or their job responsibilities might be able to be reallocated if that's possible, but reallocation of essential functions is not required. So if you can reallocate some non-essential functions, that might be a permissible, reasonable accommodation. Part-time work could be a reasonable accommodation, and sometimes employees are willing to accept part-time work rather than coming to the location of the job. Additional training might be a reasonable accommodation or a flexible work schedule. Next slide, please. So what the ADA and the New York Human Rights Law do not require is forcing you to allow remote work because the employee's family member has a serious health condition. It's the disability of the employee herself or himself, not the disability of a family member. And you will, I'm sure, hear these sorts of arguments, but the law does not require that. It does not require that the employer provide transportation to the workplace, unless, of course, you do that for other employees. Then you would need to consider doing it for this particular employee. And the law does not require bumping a coworker from a position that the employee with a disability could do as a reasonable accommodation, unless, of course, the collective bargaining provision or company policy allows or even requires bumping. Then you would need to consider that. Next slide, please. Okay, so before the issue arises, make sure, as I said, that your job descriptions are up to date and accurate. Don't assume that in-person work is an essential function of the position. You may have to prove that it is. Ensure that supervisors know the requirements for the interactive process. Supervisors, frankly, can create real problems for the employer if they are unsympathetic to the employee's request for a reasonable accommodation, or they do not keep track. On the other hand, maybe they're too helpful, too forgiving of the employee if the employee has performance problems because they are not working at the job site. And of course, make sure that the HR department maintains a file that's separate from the employee's personnel file with information about the disability. No one except HR should have access to information about the disability. Next slide, please. Okay, so what takeaways then do we have for you? Neither the federal nor the state human rights agencies nor the courts assume that in-person work is an essential function of every job. They have changed their tune on that. And simply because a job can be done remotely doesn't mean that the employer must allow full-time remote work for an employee unless there's a request for a reasonable accommodation. Again, following the interactive process, I can't emphasize this too much. It's absolutely key. Even if the answer seems obvious, the agencies and the courts care about whether or not the employer followed the interactive process to ensure that the employee received every consideration. And then, as you've probably been reading in the press and listening in the news, mental health considerations are becoming increasingly important, not only in colleges and universities, but in workplaces everywhere, and need to be addressed thoughtfully and thoroughly. And that's it for me, Gabe.
Thank you so much, Barbara. Really useful context in this changing environment. And Barbara, we look forward to having you back on the program as always. And now let's bring Seth Gilbertson forward. Seth is here to talk about AI. Seth is a senior counsel based in our Buffalo office. Seth's been on the program many times previously and thought it would be useful to take a deep dive on the implications in the education environment. And so, Seth, I want to give you the space to move ahead, and I'm looking forward to, along with the audience, learning more. So thank you.
Thanks, Gabe. Next slide, please. I will just say, in response to Gabe, this is far from a deep dive. Although I hope Bond will be putting together some deep dive materials, this is more of a preview. As we don't have a lot of time here today, and this is certainly a topic that could justify an actual deep dive, a long form program focused solely on this issue. I hope to be doing that with you sometime over the course of the summer. But today I'm just going to try to add to the barrage of information that we're all receiving about the implications of AI in various sectors. I think I won't say or suggest that higher education is one of the most effective or is the most affected sectors, but it's certainly up there. It is obviously part of the knowledge economy, and anything that's anyone who's in the knowledge business these days should be feeling a little bit unsteady. Those of you who have been reading this introduction while I've been talking at you may hopefully you liked it, but it's not mine. This was written by ChatGPT in about 5 seconds. As I did adjust it a little bit, skim it down, edit it slightly, but for the most part, this is the kind of thing that you can produce with ChatGPT these days, just by typing in a very basic query. I think I typed in something like write introduction for presentation on AI in higher education, and this is what it came up with. So as you can see, it's not always easy to tell, but there are a few small tells here. Certainly, if you've read things that I've written before, you probably never seen me use the term reskilling. I don't even think I heard that word prior to reading it here. But besides that, it's certainly something that a human could write. Next slide, please. As we're addressing this this sort of brave new world in higher education, there are a couple of guide stars, I think, certainly in the immediate time frame that we should be focused on. One would be having clear rules that apply, so everybody knows when it's appropriate to use AI, when it's not. That goes for students, faculty, even staff should know that. There should be clear rules around this. We should be doing that now, even if we can't revamp entire policies. We can at least provide some guidance. It's exam season, final paper season. If people are doing those sorts of things now, faculty, it's going to be application time soon, or be a lot of tenure review and things like that occurring over the course of the summer. And so putting clear rules around when AI can be used, when it can't, how it can be used, how it can't, or how it shouldn't be, is important. Then we get to, if we suspect that it's been used inappropriately, how do we prove it? How do we detect it? There are detection tools. This is sort of a battle of the algorithms at this point, where you have various detection tools. There are about 10 pretty widely used ones now. I put a couple in here. Turnitin has a program. ChatGPT 0 is one of the programs that's widely used and available now. They are far from perfect. There are many different studies with many different results as to how accurate these detection tools are. The way I view them at this point is basically a very front line. They show you that there may be a problem and require something that requires further inspection. At that point, we get into the perhaps questioning an individual about something they've written, seeing if they can back up the thoughts that are expressed. Comparison to past work to see if they, use the term like reskilling that they never would have used before and maybe can't even define. Next slide, please. Those are just a few of the ways that we may we may further inquire to determine whether or not there's been an inappropriate use. Ultimately, we're looking to see if it violates our published standards. Again, it's not too late to provide guidance around what those standards are, what the rules are, so that everybody knows what everybody can define them. Have you met the standard of proof is going to be one of the most important sort of legal considerations we're going to have at this point, particularly if you're going to take action against someone for inappropriate use of AI. What is the standard you're applying? Most colleges and universities use something like preponderance of the evidence standard, which really just means you need sort of 51% sure that something has been done, that somebody's used an inappropriate or inappropriately used an AI tool. That standard can probably be met in some cases. In many of the cases I've seen, you're not sure, but you're pretty sure. It certainly is beyond just smelling fishy. There's some evidence there, enough to say it's more probable than not that somebody misused one of these tools. Clear and convincing, harder standard to meet. I think you want to have some pretty clear evidence that the individual inappropriately used it. And then we want to look, what is the appropriate penalty if we do determine that somebody has inappropriately used our AI in their work or in their academic work. I think at this point, I would be more inclined to come down a little bit harder on the employee side, where it's really a matter of misconduct, than the student side, where it's really kind of a learning opportunity, I would say at this point. I'd also say you're more likely to be able to come down and take some more definitive action if the guidance that you provided is very clear, rather than something vague that could be interpreted one way or another. So that's why we're going to be working on that going forward. Next slide, please. So those are the immediate considerations as we're trying to make our way through the final stretch of the semester here. This summer, I think a lot of us are going to be working very hard on updating policies, guidance, and our use of tools, and really trying to get our arms around this and sort of stay competitive in the arms race that this has become between those who may misuse AI and those who want to use it appropriately, or those who want to defend against misuse. So these are some of the things we're going to be working on. I think updating the academic dishonesty policies. I would suggest that almost every college and university should be updating their academic dishonesty policy this summer, unless they've done so during the course of this semester, given the sort of revolution that we've seen over the past 6 months or most of this year, and the wide availability of powerful AI tools. We're going to be working with faculty to educate them on their own use, on permissible student use, on how to incorporate this into their curriculum, and how to detect misuse. Training, whenever you're doing policy change, you want to be doing training. And again, we're going to be looking at those tools and determining which ones are best, which ones are most appropriate for various individual uses, whether that be in the employment realm or in the student academic dishonesty realm. Next slide, please. And I'm not going to go too far into this one. I'm pushing my time here, but these are some of the things we're going to be considering in the future. Reconsidering curriculum, updating our evaluation methods. My guess is there's going to be a lot fewer or a lot less use for long written work submissions that can be taken home and done, just because those are really ripe for misuse or for use of inappropriate use of AI. Is going to be a sea change for some types of curriculum, some courses. Privacy considerations are a big one. Discriminatory impacts of the use of AI have been widespread, reported in various research that's been done. Certainly, there's going to be a lot of hand-wringing over ethical and moral concerns. Intellectual property, there's a lot of litigation going on right now around intellectual property with the use of AI, who owns something that no human has created. And then job displacement. Certainly, my hope is that we can find ways to redefine jobs rather than displace them, and make better use of human reasoning and creativity, and maybe better use of AI in the role of sort of rote processing activities. So those are just a few of the things we'll be looking at as we move forward, and hope to see you all again. I'll turn it back over to Gabe.
Thank you so much, Seth. And that was a pretty deep dive for the 8 or so minutes that you had. Let's bring on our next and final speaker, Allison Roche, who's around the corner in Buffalo. And Allison recently joined Bond, as I noted at the top of the program, and brings a deep set of experiences in labor and in employment and labor, excuse me. And we wanted to have Allison speak with all of us about the Lion case, which is an interesting one that we think has resonance for many of you. We thank you for staying with us, and Allison, the floor is yours.
Thanks, Gabe. Good afternoon, everyone. Today I'll be presenting on a labor development with significant implications for U.S. employers. So in a recent decision, the National Labor Relations Board has limited how employers are permitted to respond to abusive employee outbursts in the workplace. And so this decision ultimately makes it more difficult for employers to discharge or discipline employees if the employee's misconduct is connected to union activity or workplace activism. And this topic is important because these issues tend to arise fairly often in the workplace. And whenever they arise, employers need to do a careful analysis to determine if disciplinary actions are defensible in this context. Next slide, please. So I'd like to start this presentation with a very brief roadmap, which just covers the topics that I'll be discussing this afternoon. So I'll start with an overview of the board's coverage of employee outbursts. I'll cover the board's decision in Lion Elastomers and the test that the decision sets out. And finally, I'll discuss the implication of the decision and just establish some practical steps that employers can take to avoid allegations of unfair labor practices. Next slide, please. So Section 7 of the National Labor Relations Act protects workers who engage in protected activities or concerted activities for the purpose of collective bargaining. So basically, an activity is protected if it concerns an employee's interest as employees. For example, a protected activity would include activities related to employees' hours or wages or workplace safety. And the board has long recognized that because labor disputes tend to spark strong reactions and ill feelings, that employees should be provided with some degree of latitude to express themselves. So when can an employer discipline an employee for inappropriate conduct? conduct. So traditionally, employee outbursts connected with protected activity were analyzed by the board under multiple tests that were linked to the specific setting of the outburst. And then in 2020, there was a new decision called General Motors, and the board simplified this required analysis and harmonized these 3 tests into a single test, which just focused on the motive of the employer disciplining the employee. So this was a burden shifting test, and employers could meet their burden simply by demonstrating that they would have disciplined or discharged the employee regardless of whether the employee engaged in a protected activity. Next slide, please. So recently, on May 1st of this month, the board issued a new decision which affects how employers should respond to employee outbursts. So in this new decision called Lion Elastomers LLC 2, the board has overruled General Motors, and it's now reverted back to these standard setting or these setting specific tests. And so Lion Elastomers LLC is a Texas-based rubber producer who discharged an employee because of his continued outburst during a workplace safety meeting. And so in this case, the board held that the General Motors decision did not give adequate protection to employees under the Act. And so they've again decided to apply these setting-specific tests when evaluating discipline for employee outbursts. And so this decision provides employees more license to make inappropriate and abusive comments in the workplace, so long as those comments are connected to protected activity under the Act. And so the board's decision applies retroactively to all pending abusive conduct cases. Next slide, please. So there are 3 tests, and I will just discuss them very, very briefly. And these are the tests that Lion Elastomers has set forth that now the board will be using. So under each test, the first step of the analysis requires an evaluation of whether an employee was engaged in a protected activity under Section 7. So as a reminder, a protected activity involves circumstances relating to employees' interests. Think collective bargaining, wages, hours, workplace safety, that kind of thing. And then the second step of the test depends on the setting of the outburst. So the 3 tests, so if there's an outburst to management in the workplace, the board is going to consider the place of the discussion, the subject matter of the employee's statements, the nature of the employee's outburst, and whether this outburst was caused by the employer's unfair labor practice. And if it's an employee social media post, or in most cases involving conversations among employees in the workplace, the board's going to look at, is going to use a totality of the circumstances test, and employers have to consider, the relevant surrounding context of the outburst. And then for picket line conduct, this is based on an analysis of all the circumstances to determine whether non-strikers reasonably would have been coerced or intimidated by picket line conduct. Next slide, please. So I'd now like to discuss some of the policy concerns and implications of Lion Elastomers. So something that people have noted is that this trio of tests may lead to arbitrary results and conflicting obligations under various statutes. Because in this case, employee conduct has to be treated differently depending on whether or not the employee was engaged in a protected activity. And so there are concerns that this may create a conflict between labor board law and equal opportunity laws against discrimination and harassment in the workplace. And so some are concerned that employers might risk unfair labor practice charges for swiftly addressing workers' use of overtly racist or sexist slurs in the workplace or other highly offensive behavior towards supervisors. And at this point, the board has noted that any conflicts with anti-discrimination laws will be addressed in future decisions, and they've declined to provide guidance to employers who are seeking to navigate these issues in real time. And just generally, this decision makes it more difficult for employers to discipline or terminate employees who have engaged in abusive conduct. Next slide, please. So how should employers adapt to the board's decision in Lion Elastomers? So before disciplining an employee, employers must consider the defensibility of their decision. So employers should look critically at the context of any abusive conduct, and they should consider whether the misconduct was committed during ordinary work, or is this misconduct committed during circumstances relating to employees' hours or wages or working conditions. An employer should carefully consider the circumstances surrounding profane speech or conduct during union activity prior to issuing any corrective action. So some examples might be considering where the conduct occurred, the severity of the language, the conduct displayed, and the audience. And it's recommended that employers review and update their policies related to workplace conduct and speech, as well as social media use and picket line behavior. And we also recommend that employers provide training and extra support to managers who may encounter circumstances involving union activity or workplace activism more generally. And so I'll just conclude by saying that the board's changing standards and retroactive application of these standards is fairly challenging for employers. And employers should be aware of the potential for changes in this and in other areas of the board's interpretation of the law. And they should try to implement an approach that will be defensible even under changing standards. And I'd also like to note that employers have other non-disciplinary options to deal with bad behavior connected to protected conduct, including, terminating a meeting where poor behavior occurs, or just using emails to communicate if in-person interactions are contentious. And so basically, we advise employers to work to minimize conflict and don't throw fuel on the fire if you have an employee with bad conduct. And we'll continue to provide updates in this space, including future labor board decisions and guidance. But for now, back to you, Gabe.
Allison, thank you, and welcome once more to the program. Very useful guidance. Glad you could summarize and discuss the implications of Lion with all of us here today. We thank all of you for staying with us a little bit longer than our typical 45 minutes. We appreciate your patience in that regard. A reminder that we have our workplace forums continuing. This is our annual conference series. The remaining dates are there on the slide for you in the various geographies where you may be, and we encourage you please to sign up. I'll be back with you in 2 weeks' time, and if you have any questions for any of the presenters in the interim, please reach out via the email addresses provided here. You'll be next back with we'll be next back with you, in about a week on Tuesday, and we look forward to keeping you all up to speed. We thank you for your continuing commitment to this program and wishing you a terrific afternoon.